Hello, can you hear me, guys? Hello, 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 can you hear me? Good evening, guys, good evening. So, I guess I'm audible and I'm visible. Today, decided to start a little early because I was done. So, I thought I'll just start it rather than waiting till 5:30. So, I hope you have been revising and I hope your studies have been going great. Yes. So, yesterday we had done till unit 5. We are done till discharge of the contract. So today we are going to start with unit 6. So should we start? I want to see that yes from all of you. Okay. So let's start now. So in this unit we are basically going to discuss what are the rights or rather the remedies when there is a breach. Right? What are the rights or what are the remedies in case of breach? So when we talk about remedies in case of breach, we can classify the remedies under two heads. First is the monetary rights. Monetary means money. And when I say money, money is obviously what? Damages. And other rights. Other rights, always remember, they are available apart from monetary rights. That means you can claim other rights, you can also claim the damages. That means what? You can claim other rights, you can also claim the damages. That is what is mean. Just 1 second. So what it means is you can claim the monetary rights as well as you can claim the damages. Now, the concept of damages, as in what damages you can or cannot claim, is given under the case of Hadley versus Baxendale. It's given under the case of Hadley versus Baxendale. Four rules. The first one was were laid down. The first one was any damage which arose naturally. Any damage which arose naturally. That means any damage which happened because of breach can be claimed as a matter of right. Can be claimed as a matter of right. Second, special damages cannot be claimed as a right. It can be claimed only when there is a notice of the special loss where made known. Made known means what? Not noticed. Third, remote or indirect damages. That means they are not directly related to the contract or the breach. Cannot be claimed as at all. And last one, see, I really don't know till which unit I'll be doing today. We are definitely going to finish the next 3 units, that is guarantee and indemnity. Till that, so definitely, maybe a little more. Okay? And any damage under a quasi-contract can be claimed. So if I look at the damages, the first type of damage is ordinary damage. What do I mean by ordinary damage? These damages arose naturally in the contract. That means the fact that there is a breach And the fact that the party has, I repeat again, the fact that there is a breach gives rise to these damages. And the fact that the contract was breached gives me a right to claim these damages. That means I don't have to mention in the contract I will claim the damages. The fact that there is a breach can be claimed as a matter of right. That means what? Even if I don't mention, I still have a right to claim these damages, right? Even if I don't mention, I still have a right to claim these damages. The second damage, special damages. These damages cannot be claimed as a right. It's not my right to claim these damages. Rather, I can claim these damages only when there is a notice of the special loss. That means when I have mentioned to the other party about the special circumstances, only then. Now, please understand, I don't have to tell the other person that I will claim the damage. The fact that I have made time of essence automatically gives me a right to claim these damages. Third, vindictive or exemplary damages, they are punitive in nature mostly. Punitive means punishable by way of imprisonment. And because they are punitive in nature, they are only awarded in two cases. First is breach of contract of marriage. That means after making a promise, you don't marry the person. And wrongful dishonor of a customer's check. When I say wrongful dishonor of a customer's check, what it means is the customer had balance in his account, still his check was dishonored. Can we say that these damages are basically a loss to the sentiments or the goodwill of the person? Yes, there is a loss to the goodwill of the person or loss to the sentiments of that person, and that is on what grounds these damages can be claimed, right? Businessman, for a businessman, it is implied that there is a loss of reputation. The fact that your check was dishonored, it means there's a lack of, there's a loss of reputation, and you get a right to claim these damages. On the other hand, for other parties, the loss of damage has to be proved to claim it. Sometimes it may happen that there might not be any damage due to breach. In that case, a damage which is as less as 1 rupee is given. These damages are known as nominal damage. I repeat again, sometimes it might happen that in a contract there is no damage at all. So in that case, a damage which is as less as 1 rupee is given. This is known as what? Nominal. Nominal, the word itself means, the word nominal itself means as less as could be. Right? The word nominal itself means as less as could be. Now, prefix damages. These are damages already mentioned in the contract. That is, it is not a special damage, it's an ordinary damage only. But what we have done is we have mentioned an amount that can be claimed as damage. Now, this amount becomes the ceiling limit. You cannot claim anything more than this. So, in that case, the aggrieved party will get the amount mentioned or the amount suffered, whichever is less. Because always remember, damages are not given to make profit, they are given to make good the loss suffered, right? So, they are not given to make profit, they are given to make good the loss suffered. Okay? They are given to make good the loss suffered. Excuse me. So I hope it's clear to all of you. Moving forward, now when damages already mentioned in the contract could be in the form of a penalty or could be in the form of a liquidated damage. When I say penalty, penalty means to penalize someone, and obviously if I want to penalize you, I'm not going to be lenient with you, I'm going to be very strict and harsh with you. So when I say penalty, means it is something which is very, very high as compared to the original damage suffered. So it is something which is very, very high. Whereas liquidated means what? We try to convert it in terms of money. Liquidated means what? We try to convert it in terms of money. That means the parties try to calculate or figure out the damage that they may suffer. Obviously, it cannot be exactly the same, but something which is very near to the actual damage suffered. Always remember, parties will only get what you have suffered, nothing more, nothing less. So when we talk about damages, penalty or liquidated damage, this difference is actually not given under the Indian Contract Act. Under the Indian Contract Act, depending on the situation, the court decides it will be liquidated damage or penalty. But when we talk about contracts with the government, when government has made any contract for the welfare of the public and this contract is breached, generally the penalty which is mentioned has to be paid. So that means you have to pay the penalty to the government. Now the other rights, these rights are available. So basically penalty is, let's say A says to B, I want you to repair my flat, the work to be done within 6 months. And if you fail to repair within 6 months, you have to give me the rent I earn, 2 times the rent I earn. Guys, you only tell me. Ayush, you only tell me which is what. Penalty is something very high. Liquidated damage is something which is an approximation of the real loss. So, the rent and 2 times the rent, which is what? Exactly. Guys, you all, everyone is supposed to answer, not just him. Two times rent is penalty. What about the other one? What about the other one? This rent. See, if in case there is a loss, what is the maximum loss that I will suffer? In case the delay takes place, if in case there is a delay in the work, right? Yes. In case there is a delay in the work, what is the maximum damage that I will suffer? The maximum damage that I will suffer is the rent. So obviously this rent is the liquidated damage. On the other hand, twice the rent is something which is very high compared to what I will suffer. So this is what? Penalty. I hope it's clear to all of you. Now moving on to the other rights. I already told you other rights are available apart from monetary rights. So don't forget that. It's available apart from monetary rights. सबसे पहला sue for rescission. Rescission का मतलब ही क्या होता है? To cancel. What do I mean by rescission? Rescission means to cancel. Let's say I have made a contract with you and then I want to cancel this contract with you. I don't want to perform. So will you sit and cry in every corner? Oh my God, breach, done. No, please, even God help those who help themselves. You cannot sit and cry in every corner. So what you are going to do in this case is, you are going to sue the other party to cancel the contract. This is known as sue for rescission. Right? I repeat again, this is known as what? Sue for rescission. If one party is ready to perform but the other refuses to accept, the aggrieved party can sue the other party to cancel. Yesterday also we did rescission, which was cancellation. But that happened with the consent of both the parties. But this is only because one has breached and the other cancels. So let's say A was ready, B refuses. Can A sue B to cancel the contract? Yes. Apart from that, can A also claim damages from B? Yes, because I told you that damages are available apart from, the special other rights are available apart from monetary rights. Correct? Now the next one, quantum meruit. What do I mean by quantum meruit? Quantum means quantity. Meruit means merited. So when I say quantum meruit, it means as much as is earned or as much as is merited. That means what? If the whole work is not done, in that case, even if a part of the work is done, you must pay for the part that has been done. Now there are certain rules for quantum meruit. First, contract is separable and you have done a part of the contract. You will be paid for the work done. Contract is not separable, you have done a part of the work, you will not be paid. But if the other person accepts it, he must pay for the work done. If the contract subsequently becomes void, then before the contract became void, whatever you have done, you will get for that. Fourth, if any person has done the work for another, not intending to do it gratuitously, that means if a person has done the work for another, hoping to be paid for it, so he will get money for the work that he has already done. And in case you have performed the work, you have done the work, but your work is not as per what was the desire of the promiser, still you have done the work, he cannot refuse to pay you, he must pay the reasonable charges of the work done. So these are the 5 grounds on which the claim for quantum meruit can be made. The next one, sue for specific performance. So specific performance basically means I am suing the other party to make the other party perform the contract, right? What is specific performance? I am suing the other party to make the other party perform the contract. Now, when I say specific performance is actually given in 2 cases. First, where damages are not an adequate relief. First, when damages are not an adequate relief. When I say damages are not an adequate relief, this is basically for immovable property. Damages cannot be compensated for non-performance, or the goods have no substitute in the market. Antique goods. You tell me this is, please try to imagine. You tell me, ma'am, this is a pen which was used by the king of the Ming dynasty. I'm a Chinese show lover. I decide to purchase it. Later you refuse. Can I get any other pen which was used by the king of the Ming dynasty? No. So will I take damages or I want the pen? I obviously want the pen. So I will sue you to perform. So this is what specific performance. That means sue the other party to perform the contract. The next one, sue for injunction. Always remember, both specific performance and injunction is granted under Specific Relief Act. But in specific performance, I am suing you to perform. Whereas in injunction, it is about a negative act. Where in a contract, there is a negative act, one of the parties breaches the negative act. Till you are working for me, you cannot work anywhere else. You made the contract, but you start working somewhere else. Can I sue you to stop you from working somewhere else? Yes, this is injunction. When there is a negative term and the party does not fulfill that condition, the aggrieved party can sue the other party to stop him from doing the negative act. Right? We are done with this unit. If anyone has any doubt, you ask me before I move forward. If you have any doubt, you ask me before we move forward. And as usual, you'll tell me, no, ma'am, no doubts. So let's move on to the next one. Now we are starting with the special types of contract. One more thing, please remember, when we talk about special contracts, they're very important from exam point of view. 2 questions you can get. You want me to explain the whole quantum meruit, Akshat? Sorry, Akshata. You want me to explain the whole quantum meruit? You did not understand anything that I explained? Quantum meruit means if a part of the work has been done, you should pay for the work that has been done. So let's say I have to deliver you 500 kgs of rice, but I only delivered to you 200 kgs of rice. Should I pay you for the 200 kgs or not? Should I pay you for the 200? Should you pay me for the 200 kgs or not? I had to deliver you 500 kgs of rice, only delivered 200. You accepted. Should you pay me for the 200 or not? Yes. If the contract is separable and a part of it has been done, right? And a part of it has been done, you should pay. Correct, should pay. Let's say I ask a painter to paint a picture for me, my portrait. He only painted half a portrait of me, right? He just did a pencil sketch of half the portrait. Am I liable to pay him? Am I liable to pay him? Am I liable to pay him? No. What is that half painting useful for me? Not liable. But I was amazed by the half face he was. I was looking very pretty in that half face. I was like, please give it to me, please give it to me. I want to put it in my house. Should I pay or not? Yes. Accepted, I have to pay. Yes. I have to deliver you 100 pens. I have delivered you 30 pens. New law. Selling of this pen is prohibited. I have to deliver this 100 pens to you. I have delivered 40 pens. New law. Selling of this pen is prohibited. The 40 pens that you have received, you should pay for that or not. Should pay for that or not. Akshata, everyone else is answering, but I'm expecting you to answer definitely. Yes, yes, correct. So if a contract subsequently becomes void, whatever has to be, whatever has to be paid, for, whatever has been done, you have to pay for that, right? Now tell me, um, the person has done the work, part work only, and he was hoping he will be paid for it. Isn't it your obligation to pay him for that? He did a part of the work, but whatever he did, he was hoping he will get money for that work. Should you pay him or not? Yes, because he was not intending to do it free. Someone did the work for you. I don't like the work you have done. There should be one more light here, one less light there. There should be an AC outlet here. Like I'm supposed to die in the heat or what? There should be one camera here also. Only I don't like the work you have done. I will not pay you. Can I do this or I am liable to pay for the work that is done? Should pay. If the person has done the work, not as per my requirement, but still he has done a decent job, I have to pay the reasonable price of the work that he has done. Akshata, I hope it's clear now. No, even if he has agreed, in that case, if the contract is not separable, then nothing will be paid. But if the other person has accepted it, then you have to pay for the work done. That totally depends on the situation, then, Rakshata. If you have decided to pay at the end only, not liable to pay. But if the other person has enjoyed benefits of the work, then liable to pay. Clear? Guys, is it clear? Akshata, I hope it's clear. Can we go forward? No, you're not liable. Prach, you're not liable. But if you accept it, are you liable? Yes. But if you accept it, are you liable? Yes. Okay? Can we go forward? Okay, so I hope these videos are helping you. I hope after you're done, you're going back home and revising also whatever is done. If it is, you should give a like to this, right? So moving forward to the special types of contracts, contingent and quasi. Moving forward to the next type, special. I already told you special contracts are important. Expect at least 2 questions from them in the exams for sure. The first one, contingent. What is contingent? May or may not. I will sell you the car if I get it from my father. Contingent. I will sell you my land if I'm able to buy it from the owner. Contingent. I am going to do some contract. I'm going to do something. Or I'm going to not do something if some event happens or does not happen. An agreement to do or not to do something if some event collateral does or does not happen. I agree to do something or I agree not to do something if some event happens or does not happen. Is it clear to all of you? Yes? I will give you rupees 5 lakh if your house is burned by fire. That means insurance contracts are contingent contracts. Insurance contracts are what? Contingent contracts. I hope this is clear to all of you. Yes? Can we move forward? Thank you so much, Bhaiya. Then, what are the characteristics of contingent contract? First and foremost, it is dependent on what? A future uncertain event. Second, the event must be a collateral event. That is, it should not form a part of the reciprocal promise. That means A says to B, if I will give you 1 crore if you marry C. A says to B, I will give you 1 crore if I am able to marry C. Please let me be B. I would love to get that 1 crore if someone marries someone, right? So in this case, tell me which is contingent and which is not. Tell me, guys. Which is contingent? Arey, what? Yes, Akshata. Which is contingent, which is not? One of them is not contingent. Which one? Which is contingent? Those who say first is contingent, right first. Those who say second is contingent, right second. A and B. Dono are contingent. Both are contingent. Both are contingent. One thing good about you guys, don't ask you to type anything. Ma'am, bolte jao, it's good. Asking us a reply, I will have to wait. Arey Baba, Ayush, dono mein promise to pay hai. A says to B, I'll pay you 1 crore if you marry C. In the second case, A says to B, I'll marry, if I am able to marry C, I'll pay you 1 crore. In any case, I would love to be B and I don't have to marry, but I would love to get the money. That's the whole point, right? So tell me which is contingent, which is not. If not, why not? I mean, rather tell me which is contingent. I will tell you why not. Jaldi se, I want an answer from all of you, whoever is here. First case, A says to B, I'll give you rupees 1 crore if you marry C. Second case, I'll give you 1 crore if I am able to marry C. पहला वाला केस में ए बी को बोलता है मैं तुमको 1 करोड़ दूंगा अगर तुमने बी से सी से शादी किया. सेकंड केस में ए बी को बोलता है मैं तुमको 1 करोड़ दूंगा अगर मैं शादी कर पाया सी से तो. ठीक है, अभी समझ आया सबको? नवील, डिड यू गेट इट नाउ? B is contingent. अच्छा, second one is contingent, you're saying. Okay. What about the others? Prat says second, Ratik says second, Naveel says second. बाकी सब क्या बोलोगे? Both are contingent. Okay. B, yes ma'am. What? Yes. अच्छा, ठीक है. Marrying to B is contingent. Akshata, in neither of the cases A is marrying B. In neither of the cases A is marrying B, my dear. In the first case, if you see, A says to B, I will give you money if you go and marry C. This event marriage is coming from the other party. When the marriage is coming from the other party, it is what? Reciprocal. And when it is reciprocal, it is not contingent. Because see, collateral event, that means it should not be a part of the reciprocal promise. Right? It should not form a part of the reciprocal promise. What is reciprocal promise? Dependent. I will do something if you do something. Here, I will pay you money when you marry. So this is what? Reciprocal, coming from the other party. But in the second case, I will give you 1 crore if I am able to marry C. This event is not coming from the other party. When it is not coming from the other party, it is collateral. And when it is collateral, it is what? Contingent. Akshata. First you said B, no? Anyway, did you understand, guys? Guys, did you understand? Why the first one is not contingent and why the second one is contingent? Did you understand? Hello? Did you understand? Yes. The third one, A says to B, deliver me the goods, I will pay you if I wish to. On the day of the payment, he says, I don't feel like paying. Is it contingent? No. A contingent contract can never depend on the will of the promiser. It can depend on a third party, it can depend on an uncertain event, but never on the will of the promiser. Now, going to the legal rules of enforceability, first of all, just 1 second, I'll just finish this off because nothing will be left otherwise in this. The first one, depending on the happening of an event. A says to B, I will sell you my land if I inherit it from my father. I'm giving you the same examples we discussed in the class so that you can connect to it. A says to B, I'll sell you my land if I inherit it from my father. The contract is what? A will sell the land to B. But it depends on what? It depends on whether he inherits it from his father. Now tell me guys, if he inherits, what will happen? He should sell. If he does not inherit, he will not sell. So a contingent contract dependent on an event is valid when the event happens, becomes void when the event does not happen. First of all, always remember contingent contracts are what? Valid contracts. So here, when it becomes void when the event does not happen, this is void contract. The next one is that I will give you rupees 100 if the ship does not come to the port. So let's say the ship goes dubuk, right? It's gone. The ship sinks. Sinks means it will not come to the port. The contract is what? Valid. So it is valid when the event does not happen. Ma'am, it's valid because the event happened. Please, I'm not paying you for the ship sinking. I am paying you money for the ship not coming to the port. When the ship sinks, it will not come to the port, right? So it's valid when the event does not happen and becomes void when the event happens or there is a possibility that the event will happen. Similarly, I can give a time period for the event. If it happens within a period of time, then it is valid if the event happens within that time, and it is void if the event does not happen within the time. Again, non-happening within a time, then it is valid if the event does not happen within that time, or it's void if the event happens within that time. So I will give you 500 if the ship does not come to the port within 7 days. The ship comes on the 5th day, it's void. The ship comes on the 10th day, 7 days it did not come, it's valid. I hope it's clear to all of you. Then, can it depend on the future conduct of a third party? Yes, it cannot depend on the promiser, but it can depend on the third party. A says to B, I'll give you rupees 1 crore if I'm able to marry C. The contract is completely dependent on C. If C goes and marries D, it's void, but if C goes and marries A, it's valid. The last one, contingent contract dependent on impossible events. I'll give you rupees 1 crore if I enclose the space between two parallel lines. Enclose the space, join two parallel lines. First of all, if they are parallel, they can never join, and if they join, they are not parallel. So this is what? Impossible event. And when the event is impossible, it is what? Void ab initio. I hope it's clear to all of you. I hope it's clear to all of you. So with this, we are done with contingent contract. Going forward to quasi-contract, right? So today, no, in the mock test paper, of this September attempt, I saw a question which I really liked. So once we are done with quasi-contract, we'll discuss that question today. Okay? Quasi-contract, there is no contract between the parties, but a contract is created by the imposition of law. So basically, a quasi-contract is a contract which is implied by law, correct? By the imposition of law to prevent the unjust enrichment of one at the expense of other. If there is no quasi-contract, actually what will happen? One party will enrich himself at the expense of other. To stop this kind of enrichment of one at the expense of other, quasi-contract is made. So basically this right is generally a right to money. Generally it is a right to money, or in some cases maybe liquidated sum of money. That means kind instead of kind, cash. And it is basically an obligation which is created without a contract. So it's an obligation which is created without a contract, and the right is generally to a particular person and not to the world at large. What does this mean? So let's say A has to deliver goods to B. By mistake, the goods are delivered to C. Liability for money paid or things delivered by mistake or under coercion. Yesterday we discussed that coercion wala part mein. A has to deliver goods to B. At 12 in the night, if you remember, you get a pizza delivery. Hello sir, I have a prepaid pizza for you. You're like, oh my god, manifestation power is working. You accept it. After some time, ting tong, you're just taking pictures, trying to send it, ting tong. Yes sir, so that pizza is not yours. Are you liable to return it? Yes. You open the pizza box, you're having your first, yum. Ting tong, with that pizza, you're like, sir, that pizza is not yours. We have already eaten. Sir, pay me. I don't have money. Sir, then why did you? You only gave me. So, sir, when you never ordered, why did you take? But you only gave me. So, bhaiya, aapne order nahi kiya. Why did you take it? Are you liable to pay? Yes. So, goods delivered by mistake or under coercion. When goods are delivered by mistake, there is no contract, but there is a contract that the person to whom the goods are delivered should return it back or pay the price of the goods. If a person supplies necessaries, what do I mean by necessaries? Necessaries means that those things which are suitable to the requirement of the person at that time, right? For his livelihood, for his living, those things are necessary. So a necessary supplied to a minor or to a lunatic's family, right? Or to a lunatic's family. Now when I talk about lunatic's family, family means that family which is dependent on the lunatic. If a person supplies necessaries to a minor or to a lunatic's family, the supplier shall be reimbursed from their property. This is a quasi-contract. There is no contract between them because a minor cannot make a contract. But according to quasi-contract, the supplier will be reimbursed. Obligation of a person enjoying benefit of a non-gratuitous act. You park your car, someone starts cleaning, you see, you let him do. Oh my God, amazing job he's doing. You let him do. So he's not doing, government has not hired, go today this area ka car, tomorrow that area ka car. He's doing it for his rosy roti, not rosy roti, rosy roti. So shouldn't you pay him? Yes. Now he will to say anything, you should pay him the reasonable charges. When a person has done the work for another, not intending to do so gratuitously, that means what? Intending to be paid for it, right? That means what? Intending to be paid for it, and such other person enjoys the benefit. He is liable to compensate for the services rendered. He is liable to compensate for the services rendered. मतलब क्या? मैंने आपके लिए कुछ service render किया है and I am hoping to be paid for it and you have enjoyed it. Then you must pay for it. Where is this responsibility of the finder of the goods? We will do in details when we go to bailment. That only I was saying, where did that do? Right to recover money paid for another person. I have made the payment for you. You are supposed to pay, I pay. Why I pay? To protect my interest. Why I pay? To protect my interest. A gave his property on rent to be electricity to be paid by A. A did not pay the electricity. So because A did not pay the electricity board gave a notice that we will cut off your line. If the line is cut off, B will be at loss, so B pays off. Who was supposed to pay? A. Who pays? B. Why he pays? Chumma, or he has an interest? Interest. Can he recover it from A? Yes, quasi-contract. I hope it's clear to all of you. I hope it's clear to everyone. Yes. So moving forward, so I have this. I saw today morning one nice interesting question which I want to discuss with you all. I hope everyone is clear. Anyone has any doubts? Acha, this one. This question. Read it aram se and tell me the answer. Wait, I'll just go back to the example. I don't know which example you're talking about. But anyway, give me the answer to this one right now. Why? The whole question is why. Answers are wrong. All of you, your answers are wrong. Read it again. Read it again. All of your answers, reasonings are wrong. Answers, so I don't know, reasons are wrong. Correct, Suchitra. Correct. Kajal, of wife of Ajay, is a lunatic. She purchased a diamond set of 15 lakh from a famous jeweler on credit. The jeweler demanded the payment from her husband Ajay. The jewelers filed a suit against Ajay for recovery of the price. Decide whether the jeweler is exactly. So if you see necessaries, only liability is for those necessaries, for those goods which are necessaries. Here, this is not necessary. So she cannot recover. Correct? Here you cannot use that agent, wife as an agent. No, rather this is more of like, claim for necessary supply to a lunatic. Ajay has to pay because it's not necessary, or Ajay does not have to pay because it's not a necessary, Akshata? When it is a necessary, you have to pay. When it is not a necessary, are you liable to pay? Does not because it's. Okay, now who had a doubt? AK-24. I seriously. AK-47 याद आ रहा है मुझे तो. What was your doubt in this, Bolo? B is the owner of the land, but the taxes were due by B or by A. Who defaulted in the payment of the taxes, A or B? Same example we have done in the class also. A. So who was supposed to pay? So who was supposed to pay? A was supposed to pay or B? But B has to pay to protect his land. So basically A sold his land to B on which the government taxes are due. Now if the government taxes are due, the government will seize off the land, and if the land is seized, B's land will go. So to save his land, he pays off. Who was supposed to pay? A. Who pays? B. Can he recover it? AK24, is it clear now? Okay. Now contract of indemnity and guarantee. When I say contract of indemnity, indemnity word means what? Make good the loss. So basically here, one party is promising the other party that I will make good your loss. Party 1 is saying to party 2, I will make good your loss. Which loss? Which is caused due to fault of party 1 himself or any other third party. Right? So party 1 is telling the other party that because of me or because of anyone else, if you suffer any loss, you will have to, I will compensate you for that loss. The person making the promise is called the indemnifier, and the person who makes to whom the promise is made is the indemnified or the indemnity holder. Now let's say you found a phone on the road. Your friend says it's mine and he proves everything. You give the phone to him, but you're scared. Oh my God, what if someone else comes and takes and claims that it's my phone? Why did you give it? So you are like, should I give? Should I not? Give not, give not. He's like, Arey Baba, it is mine. You're like, no, I'm not doubting you, but what if? So your friend says, okay, fine. I give in writing. If tomorrow someone else comes and claims this, any loss you suffer, I will give you that loss. Contract of indemnity. One day someone comes and says, hey, you found my phone. Which phone? That phone. But that was my friend's phone. No, it was my phone. No, he proved everything. Arey, he is my neighbor. He knows everything about my house. His whole interest in his life is to know everything in my house. He knows the passwords, everything. It's my phone. So this person files a case against you. So when he files a case against you, obviously you also have to hire a lawyer. So whatever cost you incur in that suit, can you recover from that person? Yes. Now, in the court it was proved. In the court it was proved that you are not, he is the owner and you have given it to the wrong person. Court tells you, you have to give him compensation. Can you claim that compensation also from your friend? Yes. This person says, I'll sue you. You start laughing. Excuse me, I'm going to sue you. You're like, go, sue no. What is to me? Bro, I'm telling you, I'm going to sue you. Yeah, sue no. I don't care. Why are you so easy? I'm telling you, I'm going to file a case against you and you're... I don't give a damn because I know my grandson will give you that damages, not me. So please go file a case. And maybe my grandson will give your grandson only. Then he's like, oh my God, case can go on for years and years. So you tell him, look, I know I'm at wrong. I'm very sorry. I will give you compensation. So you settle it outside the court. So whatever you pay as a compromise for this suit, can you recover that also? Yes. So what are the rights of the indemnity holder? He can recover any cost of the suit, any damages paid in the suit, or any compromise paid for the suit. I hope it is clear to all of you. When does the liability of the indemnifier starts? The law does not give any time, but the moment the liability of indemnified starts the liability of indemnifier. That means when is indemnifier liable to pay, Act doesn't say. But the moment the indemnified becomes liable, obviously the indemnifier will also become liable. I hope it's clear to all of you. Now, what is insurance? Is it a contract of indemnity? Now, if I look at the definition, no. The definition says due to the fault of party 1 or any other party. That means man-made causes. So, if I look at this definition, it's very evident that we are only talking about man-made causes. But in the case of Gajanan versus Madan, the court held that the definition is incomplete and even a contract of insurance will be considered as a contract of indemnity. Okay? I cannot see your message. Yeah, it can. Generally, we don't do it oral. Difficult to prove. The Act doesn't say it has to be in writing or anything, but generally we take an indemnity bond from the other person always. I hope with this we are done with indemnity. Is it clear? Anyone has any doubts? Otherwise, I'll start with guarantee. No doubt. Should I move forward then? आगे चले? Should we move forward? Yes. Now moving on to the next one, contract of guarantee. Guarantee is basically an assurance. Guarantee is basically an assurance. One party promises the other to pay or to discharge the liability of another or to perform on behalf of another if another person makes a default. That means I am promising you, if that third party does not pay on the due date or does not perform on the due date, I will perform or I will pay. So D has taken a loan from C for which S has given a guarantee. That means if D does not pay, I will pay. D is the principal debtor, the person on whose behalf the guarantee is given. C is the creditor, the person to whom the guarantee is given. S is the surety, the person who gives the guarantee. So when I look at the contract of guarantee, first of all, there are 3 contracts. What are the 3 contracts? What are the 3 contracts? One is between the debtor and the creditor. One is between the debtor and surety. One is between the creditor and surety. Debtor and creditor give me the loan. Debtor and surety give a guarantee on my behalf. Creditor and surety, I give a guarantee on behalf of debtor. So basically, every party makes 2 contracts. I repeat again, so basically every party makes 2 contracts. Now, is surety getting any consideration? No. Surety is not getting any consideration. So the consideration given for the benefit of the principal debtor is sufficient consideration for the guarantee. The consideration given for the principal debtor is sufficient guarantee for the what? I repeat again, the guarantee given for the benefit given for the principal debtor acts as a sufficient consideration for the what? Surety. Then again, the liability is a future liability or the liability exists even when the contract is made? Exists. So it's not a future liability, the liability exists at the time of the contract. And a contract of guarantee may be oral or written. Now let us say the loan amount is 10 lakh, interest 1 lakh. The creditor says, look, you are giving a guarantee. So, chalo, give it for 12 lakh. Can he do that? No. When the debtor is only liable for 11 lakh, how can I be liable for more? Right? How can I be liable for more? So, the surety's liability is coextensive. That means it extends to the liability. That means extends up to the liability of the principal debtor. That means I can be liable for 11 lakh, I can be liable for lesser amount, but never more amount. Because I am liable on your behalf. If you are only not liable for something, how can I be liable for that? Then, when is the surety liable to pay? His liability is secondary. Please understand, the creditor cannot go to him directly. He must first go to the principal debtor. So the liability of the surety is secondary and conditional. Why do I say secondary and conditional? Secondary after the principal debtor. Conditional only if he fails to pay. Once he fails to pay, the surety becomes liable. So the surety's liability arises as soon as the principal debtor makes a default. That means the moment principal debtor makes a default, the surety becomes liable. Now, let's say there is some defect in the paperwork or anything, and because of which principal debtor cannot be sued. So if the principal debtor cannot be sued, how can you sue the surety? So if the debtor cannot be held liable due to any default, then even the liability of the surety ceases. See, please understand, I am liable only because of him. If he is not liable, how can I be liable? Correct? And the last point we will do a little ahead. Thoda aage jaake we will do that point. I hope this is clear. Moving forward, what are the two types of guarantee that we have? Specific and continuing. What is specific? For a specific transaction. What is specific guarantee? For a specific transaction, for a single transaction. Can I revoke it? No. It can never be revoked. Can never be revoked. When I say continuing guarantee, it moves over a series of transaction. It moves over a series of transaction. But when I say it moves over a series of transaction, it can be time specific or money specific. I am liable for whatever. So if I say, if you sell this pen to him on credit, if he fails to pay, I'll pay. This is specific guarantee. Guarantee is already given. How can you revoke it? But when I say continuing guarantee, whatever pen you sell him on credit, if he does not pay, I will pay. It moves over a series of transactions. Can I revoke it? Yes. The moment I revoke, whatever has happened, I am liable. For future transactions, I am not liable. Whatever goods you sell him on credit for the next 6 months, if he does not pay, I'll pay. Is this also a valid continuing guarantee? Yes. That means continuing guarantee can be what? Time specific. Whatever goods you sell him on credit up to 1 lakh, if he doesn't pay, I will pay. Is it also a valid guarantee? Yes. That means it can be money bound also. In case of continuing guarantee, let us say the guarantee is given here. Here it is revoked. So whatever is done here liable, but whatever is done here not liable. I hope it's clear to all of you. Now, rights of the surety. This surety has rights both against the principal debtor, the creditor and the co-surety. When I say against the principal debtor, he has rights of subrogation and rights of indemnification. Indemnification means when, let's say, on the due date, let's say D has taken a loan of 10 lakh from C, S has given a guarantee. On due date, S pays C. So when S pays C, can S go and recover the money from D? Guys, tell me. So answer, you have had a good time since the past 10 minutes sitting aram se. Tell me. Can recover. Can recover. Yes, he can recover. This is indemnification. To recover the money from the principal debtor once he has paid off. Now, the moment he pays off, C is out of the picture. And now, can I say S becomes the creditor of D? Yes. And all the rights of C passes on to S. This is subrogation, to step into the shoes. So basically step into the shoes of the creditor. Now guys, please understand, he does not tell the creditor, hey, open your shoes, I'll wear. No, please. All the rights of the creditor passes on to him. Is it clear to all of you? Yes? Rights against the creditor is only one right, right against creditor's security. Rights against creditor's security. Listen very carefully. D took a loan of 15 lakh from C. S gave a guarantee. Apart from this, D gave a jewelry of 12 lakh to C. Now on the due date, when S pays off C, can I say S will have a right over the jewelry? Yes. When on the due date, the surety pays off the creditor, any security taken by the creditor passes on to the surety. So now S will have a right over the jewelry. Please listen very carefully now. I just said S will have a right over the jewelry. Fine. Now tell me guys, in this case, okay, S was not aware of the jewelry. I want an answer from all of you. S was not aware of the jewelry. Will he still have rights over the jewelry? Yes. So see here, surety is entitled to every security which the creditor has against the principal debtor, whether he knows about the existence of it or not. Right? Whether he knows about its existence or not. Whether he knows that the jewelry is there or not, he will have a right. Is it clear to all of you? Yes? Now, C returns the jewelry to D. What will happen? C returns the jewelry to D. What will happen, guys? Tell me. Bolo, I'm waiting. Exactly. He'll be discharged up to 12 lakh. I hope it's clear. So if the creditor loses or parts with the security without the consent of the surety shall be discharged to the extent of the value of the security. Right? Subrogation means to step in place of another person. The moment he pays off C, he becomes the creditor. And all the rights of the creditor, like the creditor can sue the debtor, that right passes on to the surety. So he gets all the rights over the debtor as the creditor would have. Now, rights against co-sureties. Let's say D has taken a loan of 10 lakh from C. S1 and S2 have given a guarantee. So let's say S2 pays off the whole of the 10 lakh. Can he recover 5 lakh from S1? Yes. If they are liable to the same amount, they are first of all liable, joint or severe. If one of them pays, then he shall be liable to pay an equal share of the whole debt or the part of the debt which was not paid by the principal debtor. And If they are bound by different amounts, let's say S1 is liable for 6 lakh, X2 for 4 lakh. Then if S2 pays the whole of this 10 lakh, he can recover 6 lakh from S1. So they are liable to pay equally up to their respective limits. Is it clear to all of you? Just 1 second if anyone has any doubts, otherwise we'll move forward. Moving forward, discharge of the surety by revocation. Revocation can be notice. We have already done this. In case of specific guarantee, you cannot revoke. In case of continuing guarantee, by giving a notice, you can revoke for the future transactions. Death. In case of specific guarantee, it cannot be revoked. The legal heirs will be liable for the acts of the surety. For the promises of the surety, but they are not personally liable, only for their assets. In case of continuing guarantee, the moment the surety dies, the continuing guarantee comes to an end with respect to future transactions. For the transactions already made, the legal heirs are liable, not personally, to the extent of assets inherited. In case of novation, let's say S has given a guarantee, but S has given a guarantee, let's say, but S due to some reason steps out and in place of SP comes in. So this is novation, S is discharged. The next one, conduct of the creditor. First one, any variation in the terms of the contract. Let's say the interest payable was at the rate of 12%, you made it 10% without informing the surety. So any variation in the terms of the contract between the principal debtor and the creditor without the surety's consent shall discharge the surety for all transactions after the variation. For all transactions taking place after such variation. So, any terms, if it is changed, then after the variation, the liability comes to an end. The second one, release or discharge of principal debtor. I am liable because principal debtor is liable. You release the debtor, why will I be liable? A asks B to construct a house for him, material to be given by A. S has given a guarantee. Now A did not supply the material. So guys, if A did not supply the material, can B construct the house? No. So now A goes to S and says, see, your B did not construct the house only. Now give me, you perform. Can he do that? No. By not giving the material to B, you have discharged B. So even S is discharged. So release of the principal debtor. When there is a contract between the principal debtor and the creditor, where the creditor makes composition with the principal debtor or gives time to the principal debtor or agrees not to sue the principal debtor, and the surety is not informed. the surety will be discharged. Let's say D took a loan of 10 lakh from C, S was the surety. They make a composition and make this 10 lakh as 8 lakh. They make a composition and make this 10 lakh as 8 lakh. What will happen? S is discharged. If they don't inform S, S is discharged. This 10 lakh ka loan was payable after 1 year. They increase the time from 1 to 1.5 years. What will happen? S should be informed. They don't inform S. S will be discharged. D says, whatever you do, you don't sue me. So he says, C, whatever happens, don't sue me. C agrees. S is discharged. So any composition between the principal debtor or creditor gives time to principal debtor or agrees not to sue the principal debtor and the surety is not informed, the surety will be discharged. And now I have a question for all of you having a good gala time sitting there not doing anything. D has taken a loan of 10 lakh from C. S has given a guarantee. Now A goes and tells C, please don't sue D. And S is not informed. A goes and tells C, please don't sue D. And S is not informed. Is S discharged? Is S discharged? Okay. Others. Because see here very clearly it is given the contract is between the principal debtor and the creditor, right? Here he is agreeing with a third party. So yes. So where the creditor contracts with a third party, giving time to the principal debtor or agrees with a third party not to sue the principal debtor, shall not discharge the surety. Correct? Shall not discharge the surety. I hope it's clear to all of you. Now, the payment was supposed to be made today. For 1 year, C did not do anything. After 1 year, C goes to recover the money. Is S discharged? The payment was supposed to be made today. C was like, anyway, I will recover. 3 years time barred. After 1 year, he goes to recover. Is S discharged? I'm waiting. Is S discharged? No. Just a forbearance. Forbearance means I'm just not doing something. On the part of the creditor to sue the principal debtor or enforce any remedy against him without any agreement does not discharge the surety. It's not that he agreed I will not sue you or agreed to give him time. I am not, 3 years is there. I'm not suing, just that. Does not discharge the surety. I hope it's clear to all of you. Now there is one more heading here. Discharge by invalidation of the contract. The first guarantee is obtained by misrepresentation. That means what? Where the bailer, where the creditor gets a guarantee by misrepresenting the material facts, the guarantee is invalid. Then second is guarantee is obtained. So basically inside this there are plastic, covers, and we had told them very specifically we want only copper covers. He says, yeah, yeah, copper covers, and gives us. Can we say it is misrepresentation of the material facts? Yes. Can we say I'm discharged? Yes. Guarantee is obtained by concealment of material facts. You have an employee who has been doing fraud. You come to me and you say, ma'am, you will give guarantee for all my employees. I'm like, why? No, ma'am, just like that. I'm taking guarantee for my employees, makes it good for us. I'm like, okay, no problem. I'll give. After some days, you're like, ma'am, you've given a guarantee. This employee is doing fraud. I'm like, doing fraud? Yeah, he was doing fraud from day one. That is why I took your guarantee. I'm like, you never told me. Not necessary, ma'am. Am I discharged or am I not discharged? I'm discharged. Why? Because you never disclosed this fact. Or third one, where one of the co-sureties refuses to join. So basically what happens is, if the contract specifies that one of the surety is liable only when the other co-sureties join, then in that case, if they refuse to join, this one co-surety will not be liable. That means S1 and S2 are there. C goes to S2 and gets a signature, and S1 doesn't sign. S2 is liable. But what S2 did was signed and wrote liable only when S1 signs. So has put a condition that liability arises only when the other party joins. Now only if S1 signs, then S2 will be liable, otherwise not liable. So with this we are done with guarantee. If anyone has any doubt, you ask me, otherwise we'll move forward. Then he is not concealing, Rakshita. Then it is not concealing, no? He is not concealing then. Can we go forward? You want me to do this today or tomorrow? Tomorrow will be one last session for it. Obviously, we'll not complete this complete unit, will not finish. Should we do a part of this unit and the rest tomorrow, or what should we do? You guys tell me. As you will say, we'll do that. The whole unit tomorrow? ठीक है, चलो. Then we'll end it here. Please do revise whatever we have done. ठीक है? The Swift scans of contract rest all are updated and has been put. ठीक है? You can check them. It's already updated. You can check the link also in the description box below. You'll get it. Only contract act is left, which I'll upload hopefully today only, or otherwise tomorrow morning I'll be uploading it first thing in the morning. So please go and check the questions, solve the questions and all. Revise whatever we have done. Time is now very less and exams are approaching, literally knocking on the door. So keep studying, happy learning, and stay motivated, guys. I'll see you all tomorrow. Thank you so much.